where we left off is here, just the fact that you must work in the best interest of the company and you cannot knowingly harm the company. Moving along, still on section 76, what we've done here is we've unpacked it and simplified it. When you get your Companies Act next month, you'll see how long and convoluted it is. It has its subsections, subparagraphs, sub-items, but this is the essence of the section. So I forget now who it is that we engaged on the question about, oh yes, this lady, about, giving information to the board. The question was, if your sister on paper looks like the best possible candidate for printing, but she sucks, do you have a duty to disclose it to the board? I think it would fall under this provision that in addition to working in the best interest of the company and not harming the company, a director also must communicate to the board at the earliest practicable opportunity any information that comes to the director's attention, unless the director reasonably believes that the information is immaterial to the company, generally available to the public, or known to the other directors, or is bound not to disclose that information by legal or ethical obligations. So these are the only instances when you would not disclose relevant information to the company. Every other time, relevant information, if you sit as a board, you have the duty to act in the best interest of the company, you would have to disclose relevant information. So the idea of the question of, if your poor sister, I hope you don't have a real sister, if your friend is not the best possible supplier for a particular service, you have to disclose that to the board. Okay, yes. Going back, yes.
You're a director, you sit on both of them.
Yes.
You know that Subco is bluffing just so that something must go through and should recover financially. However, that is a bluff.
Yes.
So it goes against the interest of Holdco. But if Holdco goes with this deal, it helps both.
Well, number one, if it's a bluff, and we actually have a case on that, if it's misrepresentation, essentially, that's improper conduct, and you have a duty to speak against it at Subco, but also you aren't bound not to disclose the information by a legal or ethical obligation. So your obligation to act in the best interest of Subco is not covered in instances of impropriety, misrepresentation, fraud, corruption. So you definitely can disclose that to Holdco. You have to act against it here, and you're at liberty to disclose it to Holdco because it is material. It's material to the company. You have to disclose it because it's material. It's not generally available publicly, and also you're not bound by law to keep a secret or keep secret impropriety.
And the fact that if you keep quiet, it helps both companies?
It's still fraud, it's still misrepresentation. You still have a duty to act in the best interest of the company, and that includes ensuring that Subco and the board of Subco doesn't conduct itself in an unethical way. Yeah. Okay. Then the next slide. Sorry, could we go to the next slide? Just calibrating myself here. So, as I said, it's a long section, so it continues on that a director, when acting in the capacity, must exercise the powers and perform the functions of a director in good faith and for a proper purpose. So these are the elements of the common law fiduciary duties that are now codified in our law. And then in the interest of the company, in the best interest of the company, and then this is also the importation of the common law duty of care, skill, and diligence. Remember at the beginning when we talked about the historical overview, fiduciary duties, that you could be held delictually liable for some form of, professional negligence. So here, now the Act actually incorporates it and says that you have to exercise your duties with a degree of care, skill, and diligence that may reasonably be expected of a person carrying out the same functions in relation to the company as those carried out by that director, and having a general knowledge, skill, and experience of that director. So they understand that not every director must be an expert in a particular area. That's why you should have, a broad set of skills at board level, and also you have the right to seek professional legal advice or professional advice, be it legal or financial. However, if you agree to sit as the chairperson of the audit committee, number one, King 4, as we'll talk about, already says that that person should be independent. But you agree to sit as the chairperson of the audit committee. You don't have accounting background at all. For instance, you're a lawyer. Everybody knows lawyers are very bad at math. Some, okay. As I'm reminded, some. And you can be held liable because you're carrying out those functions of the chairperson of the audit committee, yet you have no knowledge of financial matters. You can be held liable, essentially. And also the fact, having the general knowledge, skill, and experience of that director. You're not expected to be a chartered accountant to be the chairperson of the audit committee, but you must, your skills must be aligned with the roles that you take, failing which you can be held liable. Next slide, please. Okay, questions?
Maybe just a quick question on that. So let's say you're appointed by the board as a director, whether executive, non-executive, and they feel that your experience and your skills and so forth match the requirements for that directorship. Is that a retort of some sort? Does that exonerate you later on? Work in that position for a year or two, and there's a big blunder because of some decision that you made or a string of decisions that you made. Can it then be said that you're not skilled and experienced and that's your fault, you should have said no to the position?
Yeah.
How does that work?
Yeah, so, that's exactly true. If I can just say, with one of our big corporate clients, every time we hold these workshops, they tell us that we know you've done a good job when people reject their appointment as a director or try and step down, because you need to understand the liabilities and just the responsibility that you attract by taking on this very important position. So likewise, if you're an ordinary board member and they want to appoint you to chair a particular subcommittee, and you yourself know you don't have the skills to, to execute those functions with the relevant care, skill, and diligence, you should say no. And that's why also, when we spoke about appointment of directors, it's not enough to just receive an appointment letter. You must also accept. You can be held to account for that. And we actually do get directors saying, actually, I'd rather not be a director on this particular company because maybe it's an insurance subsidiary or some other kind of subsidiary. Okay, sorry. Next slide, please. I think somebody is standing in front of the... Okay. So, the next case, now we get into the meat of it, so like the real life examples. So it's not just theory, hopefully you'll be more engaged. Does anybody have any questions on section 76 before I proceed on the case law? No. Okay, so this is the fisheries case. It's actually one of the landmark cases or precedents. So precedents is essentially the case that sets out the common law quite nicely. It's the accepted legal position, and it's applied by other courts. This is that case. If I can just quickly run through the facts, it's not up there, but essentially what happened was Fisheries was this company, and there was another company that ISCOR. So Fisheries is a particular company. ISCOR was another company that held shares in Fisheries. ISCOR, being a shareholder of Fisheries, had a right to, so it would be kind of this kind of structure. It's not holdco and JV, but like, there's more than one shareholder. ISCO had a majority shareholding. It had the right to nominate certain directors to sit on the board of Fisheries. And then Fisheries, after it had actually maybe I should draw it. So Fisheries, I'll just say fish. ISC. That's ISCO. There were other shareholders, and then of course there were directors. ISCO appointed two directors, two nominee directors to sit on the board of fisheries. What happened then is once, the board was constituted, fisheries took on a loan from ISCO, which is the big majority shareholder. It was cash flushed, it was able to loan money to fisheries. Now these two directors who kind of approached fisheries to kind of invest it approached ISCO to invest in fisheries, they signed suretyship for this loan. Just these two directors, not the nominee directors, but the two directors. I hope you're following me. The two directors signed surety for the debt that fisheries took from ISCO. Then the company, the fisheries, didn't perform so well. The company went down, and ISCO said, hey, wait a minute, fisheries, you owe me money, and because you're going down, you don't have the money to pay, I'm going to now go after the suretyship agreements. Now these two directors tried to say that, no, even though we signed surety, you had appointed two nominee directors to sit on the board of fisheries. They should have been aware of the financial position and they shouldn't have allowed us to take out the loan. So basically they were trying to say that it's their fault. But at the end of the day, they signed suretyship. And this is where the court, in addressing the facts and applying the law, made some very important utterances about the role of non-executive directors, because the nominee directors as well were non-executive directors. First, the court said that nowhere are the director's duties and qualifications listed as being equal to those of an accountant or an auditor. Nor is he required to have special business acumen or expertise or singular ability or intelligence or even experience in the business of the company. He is, however, nevertheless, expected to exercise the care which can be reasonably expected of a person with his knowledge and experience. A director is not liable for mere errors of judgment in respect of all duties that may properly be left to some other official a director is in the absence of grounds for suspicion justified in trusting that official to perform such duties. So essentially, maybe there was a proposal or a suggestion, recommendation from the accountants of fisheries that actually we need a loan and we can get a loan from ISCO. That was actioned upon. It didn't go so well. Things went bad. And the directors, essentially the court said the directors that signed surety, the directors that signed surety were liable for that surety. They couldn't now try and exonerate themselves by saying that these directors are to blame because they shouldn't have agreed to the decision. Does that make sense? So it's a very important case. It was pre the Companies Act. It was pre the Companies Act, but it essentially laid out the position which was eventually even imported into the Companies Act. Number one, it was applied time and time again. Actually, we're currently applying it in the ESCOM case, but it was also imported into the Companies Act. Fisheries then said he's entitled to accept and rely on the judgment, information, and advice of management unless there are proper reasons to query such. Similarly, he is not expected to examine entries in the company's books. Obviously, a director exercising reasonable care would not accept information and advice blindly. He would accept it and he would be entitled to rely on it, but he would give it due consideration and exercise his own judgment in light thereof. The court found that the nominee directors did just that, and that the surety directors, their defense held no water. But I don't know if you recall Vuyo mentioning the business judgment rule. That is the first time that the business judgment rule was spelled out in case law, and then section 76.5 actually spells it out further. Let me actually go to the section. You'll see it in your relevant sections at the end of your packs, but it says, the business judgment rule, directors would have fulfilled these duties, so all of the duties of care, skill, and diligence as espoused in section 76, the whole of section 76. They would have fulfilled these duties if they can demonstrate that they have satisfied the above obligations, took diligent steps to properly be informed, rationally believed that their decision was in the best interest of the company, and that they had no personal financial interest in the matter and complied with Section 75 of the Act. So that's the one case, fisheries, which is really great. Are there any questions on that? So when considering whether or not to take up the position of director, you don't have to be an expert in the relevant field. It's just a question of whether or not you can be effective on that board. And if you are of the view that you can be effective despite the fact that you don't have a special skill, you should take it on and you should be effective. However, if you genuinely believe that you cannot be effective, then you should ensure that you give that due consideration before taking up the role. And then the second case, this relates to the signing off of financial statements, but it still deals with the issue of duty of care, skill, and diligence in understanding matters that you're meant to exercise your discretion and your decision-making capacity on. So it's often referred to as the Centro case. It's an Australian case, but it's actually been cited in a lot of our company case law because it's an open and shut case. Centro was the name of the company, and essentially, I think I actually put the facts in here, but Centro had a number of boards of directors on the board of directors. Not all of them were accountants, but yeah, we'll see what they did. So the court in this case re-emphasized the responsibility of every director, including non-executive directors, to pay appropriate attention to the business of the company and to give any advice due consideration and exercise his or her own judgment in light thereof. This case is relevant to directors of South African companies because the Act indicates that a court, when interpreting or applying the provisions of the Act, may consider foreign company law. So that's why our courts apply this foreign law as well. The facts in this case, the non-executive chairman and 6 other non-executive directors and the chief financial officer of Central Property Group faced allegations by the Australian Securities and Investment Commission that they had contravened sections of the Corporations Act, which is the Australian version of our Companies Act, arising from their approval of the consolidated financial statements of Central, which incorrectly reflected substantial short-term borrowings as non-current liabilities. I can unpack what that means, but they had a duty, just like in our company law, the board of directors had a duty to sign off on the financial statements. What these people did is, a non-current liability is a liability that isn't due within the next 12 months. It's due sometime in the future. It has an impact on the financial outlook of the company. And what they did is they had short-term borrowings, which makes it a current liability. Why? Because it's a short-term borrowing. It is due within the period of 12 months. And that would have also affected the financial prospects of the company. They had substantial short-term borrowings. So let's just say they had R1 billion. They had R1 billion loan that was due within the next 6 months. However, on the annual financial statements, they showed it as a non-current liability, thereby giving shareholders the impression that they had a long time to cover this huge debt when actually they didn't. And so they were found, they were found guilty and personally liable. Okay. Sorry. Guys, could you just help me with the slides? It's not responding in time. The slide that says similar to South Africa's Companies Act. Okay. Yeah, similar to South Africa's Companies Act, the Australian Corporations Act also requires the board to approve financial statements. So a question for the House. I see people are getting tired now. Maybe we should learn while standing. I'm joking. So to what extent can reliance be placed on the audit committee and the finance team? This has already been touched on in the business judgment rule and in the discussion around Section 76. So one of their defenses was that the auditors told me it was fine. The finance team told me it was fine. Any takers? To what extent? Yes, but think about the fisheries case that we just discussed. So you can't rely on it uncritically. Yeah. Because essentially you would know, as the board, 6 months ago, we took out a R1 billion loan. It was due in 6 months. That's a substantial short-term borrowing. You should have known that. So as a board member, that should have been within your own personal knowledge. So even if later the auditors come to you and say, no, it's fine to reflect it as a non-current liability, what should you have, as a director, have done? Applied your mind. And essentially that's what they failed to do.
Is this similar to what is happening currently with Stanley?
No.
Their go-in takee is suing to say you gave us wrong financials and the wrong status of the company, and instead of you giving us money, we gave our company to you in exchange of shares, and now they want the company back.
There was a lot of financial misrepresentation. It's not the exact same issue. Steinhoff is another issue. We'll actually have a case study discussion on it. But essentially, it was financial misrepresentation. And that's why they were held liable. And in the same way, as a matter of fact, the board of Steinhoff should be held liable. We've never dealt with a corporate scandal of that magnitude in our country before, and it's really going to be a litmus test to how well our laws operate. Yes.
This word reasonable makes me afraid. Because it says a reasonable person and it says that you must be reasonable. So even though you don't understand accounting, but which means if I'm appointed as a director, I should be able to source from somebody to tell me what are the implications of this. So that if I make a decision, which means a reasonable person would then say that, no, man, I cannot make this decision unless I've sourced more information for me to be able to justify the decision.
Yeah. So that's precisely what the Companies Act requires of you to do. But the reasonableness...
The word was reasonable. You can't just read it like that.
Well, it says, that's why the Companies Act goes on to say, you know, a reasonable person acting in that capacity, having that degree of experience, you know, there are various things you have to consider before you can decide whether or not somebody was being unreasonable. But with the Centro case, it's quite clear. A short-term borrowing of R1 billion, you can't say it's a non-current liability, because that actually substantially affects your bottom line for the present financial year, and you're trying to kind of put it in another financial year when, as a matter of fact, it should affect the bottom line of this financial year. It was completely unreasonable. So, any questions? Sorry. Okay, so the judgment. In analyzing the director's duty of care, skill, and diligence, the court commented, all directors must carefully read and understand financial statements before they form the opinions which are to be expressed. Such a reading and understanding would require the director to consider whether the financial statements were consistent with his or her knowledge of the company's financial position. So there we go back to the fact that 6 months ago you approved a resolution to take out a substantial loan, short-term loan. A director is not relieved of the duty to pay attention to the company's affairs, which might reasonably be expected to attract inquiry, even outside the area of the director's expertise. I think everyone here can be like, no, but guys, you know, this thing is due in 6 months, and in 6 months is still this financial year. As a matter of fact, in 6 months, it's still within 12 months. It can't be a non-current liability. Then the court concluded that each director failed to exercise the degree of care, skill, and diligence required by law in the course of their review of the financial statements, and as such can be held liable for the losses suffered by that company as a result of their failure to comply to their duties. That's, yeah, quite clear cut.
So does it, the corruption watch ESCOM issue, running along this line?
Yeah, try and get 400 billion from, I'm joking. No, this is a delinquency application. It's not a damages application. So when next month, when we talk about the different actions that are available, you'll see that certain actions are available to recover monies from delinquent people. This is just to ensure that the public are protected from these people holding positions of power in the future in SOEs. Okay. Could you go back? Sorry, I think you went forward. Okay, yes, to the last slide, the pinfold case. Next slide. Thank you. Okay, so the pinfold case, I'm going to very quickly run through the facts of this case. Essentially what happened in this matter is that the board of directors lied to a particular a particular shareholder. They misrepresented the fact that there were ongoing civil and criminal proceedings against the company. They misrepresented that certain IP rights had already been registered when they were still in the pipeline. So for instance, to say that, yeah, we have a patent on this invention, but you don't. That has a significant impact on the prospects of the business, because if you don't have a patent, then the value of the idea of the invention isn't fully yours. You haven't fully protected it as yours. And then of course they failed to conclude financial statements for 2 years running, and what they tried to do is blame the auditors and say, yeah, but the auditors didn't prepare financial statements. As a board, you know that each year you need to approve financial statements, and you need to ensure that those within the company are doing the relevant work to put those in place. So what the shareholders in this company did was apply for the winding up of the company in terms of Section 81E of the Companies Act. We'll get to what that section says, but oh yeah, we get to it here. It allows the shareholders to wind up a company in circumstances where directors are acting in a fraudulent or illegal manner, or where the company's assets are being misapplied or wasted. The court found that the directors had made various misrepresentations to the shareholders and other stakeholders in the business. The court further found that the directors were derelict in their duties, so essentially they failed to exercise their duties, particularly with regards to their failure to publish financial statements for 2 consecutive years. They sought to blame this on the company's auditor, but the court emphasized that this is a director's duty and the responsibility remains with them. Yeah, I think the case law is quite clear-cut, but are there any questions? Because maybe it's not as clear-cut. Okay, so what are the lessons learned? Number 1, the decision to accept the appointment to the board of a company should not be taken lightly. A director cannot uncritically rely on officials of the company and needs to be confident that he or she is able to pay adequate personal attention to the business of the company. Each director is obliged to apply their own mind, i.e. bring their own skill and experience to the table, to the facts at hand, and cannot be derelict in their duties. Directors are expected to ensure that they make a concerted effort to understand the business of the company and the information placed in front of them, and to apply an inquiring mind to such information. Just by way of example, in the Central case, if you knew 6 months ago there's a R1 billion loan that you took out, you don't see it in short-term liabilities, you should ask, where's this loan? Where is it currently reflected? Even if you didn't see it being reflected in non-current liabilities, you should have known that it's being reflected on the books. And then failure to properly execute on directors' duties can be dire. Essentially, as we've seen in the Central case, they were held personally liable. Thank you. Okay, then the next one is personal financial interests, and it will also touch on conflict of interest. This is Section 75 of the Companies Act. Again, like Section 76, and as you'll see next month, Section 77, all of these sections apply to directors, alternate directors, prescribed officers, and board committee members. Maybe just to jog your memory, who remembers what a prescribed officer would be? Or can you give me an example of what a prescribed officer would be? Maybe hands up so we can give away. I heard some right answers. Yes. Only if.
Only if you perform duties that hold on.
Mm.
Structures.
I can see you have it in there.
Okay, so if your scope of work is in line or same as of the director,
Yeah,
then you are
Yeah.
prescribed
yeah.
officer.
So material influence. So a company secretary, if they deviate from their duties and start having a material influence, they can be a prescribed officer. But who said senior manager? And don't lie. Oh, there we go. Do you have one of these? Oh, okay. Yeah, senior managers are actually almost automatically prescribed officers because they do have a material influence on the direction of a company. Now, if a person is the only, this is one exception. So if they're the only director of the company, like in the case of a small business, but does not hold any beneficial interest in the issued shares of the company, that person may not approve or enter into any agreement in which she or a related person has a personal financial interest, or as a director, determine any other matter which she or a related person has a personal financial interest. So for instance, if it's a small business, you're only one director, but you're not the only shareholder. You can't make these determinations alone unless the agreement or determination is approved by an ordinary resolution of the shareholders after the director has disclosed the nature and extent of the interest in the company. So if you have one director, but not only one shareholder, they can't just make these decisions. They have to get the approval of shareholders as well. So if you run a small business, for instance, and you and your friend are the shareholders, but maybe your friend is working full-time and you're the only director, you're the only executive shareholder, executive director, and also a shareholder, you can't make these decisions without the approval of your fellow shareholder. Is that clear? Okay. Next slide, please. Okay, a director may disclose a financial interest by delivering a written notice, either to the board or to the shareholders, setting out the nature and extent of the interest to be used generally for purposes of Section 75 until changed or withdrawn by further notice from that director. What this is the disclosure register that I spoke about. So for instance, if you say, hey guys, listen, I've got a company, and this is how this company operates, and you keep it as a financial interest because maybe they operate in a similar field, then that will stay until the situation changes, essentially. Okay, if a director of a company has a personal financial interest in respect of a matter to be considered at a meeting of the board of directors, subject to certain exceptions, like the exceptions that I spoke about just now about the one director and the two shareholders, that director must disclose his or her interest, the material information, observations, or insights, if so requested by the board, and thereafter excuse herself from the meeting. So if personal financial interest, everybody generally understand what that is? You are a related person. There's some way that you could benefit from a decision of the board. Yeah? So you must excuse yourself from the meeting, or you can say that you won't vote on the matter to be voted about. And then a disclosure in respect of an agreement may be made retrospectively. However, such an agreement is valid only if it is then approved subsequent to disclosure or if the court declares as such. Now, that's not a straightforward question, but what it means is that I always give this example of Tiffany. So if Tiffany is a board member on company X and her dad's company supplies a particular product that the company needs and she votes on it, and her dad actually gets it, then subsequent to that, Tiffany can come back to her fellow board members and say, oh guys, by the way, that company that you approved, that's my dad's company. The board can agree to ratify it. So they say, okay, thanks for informing us after the fact, it's fine. The alternative is, let's say the board is very unhappy, they find out, no, Tiffany, now that we've approved company XYZ, and we've met the director, and he actually looks a lot like you. Is that your dad? And then the board decides they're going to reject it. Tiffany's dad can go to court and say, no, but there was nothing improper about my appointment because I'm the only person that can, maybe, for example, supply this product. Then the court can ratify it. So 2 ways that an improper decision can be made proper is if the board ratifies it or if a court ratifies it, declares it valid. So a court is vested with the power to declare any transaction or agreement valid that had been approved by the board or shareholders, as the case may be, despite the failure of the director to satisfy the disclosure requirements in this section. Clear? Yes. Okay. I hope you guys aren't just saying yes because you're tired. Oh, thank you. Okay. So avoiding conflicts of interest is one of the core duties of a director. Do any of you have examples of when you came into a situation where there was a conflict of interest? Or can you give me examples, outside of the ones I've given you, of possible other conflicts of interest? I'm going to call out names. I hope you wake up. 3, 2... Gideon. There's a Gideon here somewhere. Oh, there we go. An example of a conflict of interest.
According to my experience or where I'm working, if one is a board of director and a manager within the workshop, and then the wife is in HR, and then the child is in finance. Isn't that a conflict of interest?
Not necessarily, unless. So, okay, maybe I should ask more generally. What do you understand by conflict of interest, and where does that conflict lie? It's a conflict between who and who. Whose interests and whose interests?
Conflict of interest, I would say it's trading with maybe possibly a relative or a child.
Yeah, that's an example of a conflict of interest. Yeah, so the idea of a conflict of interest here is a conflict between my interests and the company's interests. So I, as a director, have a duty to act in the best interests of the company. I can never use my role as a director to act in my own interests. So trading with a relative would be a conflict of interest that you'd have to declare. And I think it's really important that we generally understand this concept, because that's actually where most of the corruption lies. And sometimes people think that they're okay, hey? Actually, too often people think that they're above board when they're not. Yes?
In a situation whereby you're a director, but there is a small contract that doesn't even come to the board level, but because I'm the director of the company called ABC, and my son got a tender just to supply stationery, and I didn't know, or I knew, but there's a conflict of interest, but it was not within my scope of work. I didn't even, it doesn't even come to me.
Well, if you can prove that you didn't know, then you didn't make a decision. Is that before or after the fact? While it's happening, then you do have a duty to disclose to the board. But of course, if it's the most favorable supplier, there's nothing wrong with proceeding with that. So here, the act doesn't say Tiffany's dad, going back to the example of Tiffany's dad can't get the contract. The act says that in order to, if you're making a decision, you need to disclose it. And as a matter of fact, you can't be involved in the decision. If you weren't involved in the decision, then there isn't a real conflict of interest.
So if I wasn't involved, then it's not. But I knew. And already, because they know it's
Yeah,
me,
yeah,
it's my son,
yeah.
already they gave him a contract.
Then they are not acting independently. Then they are maybe acting in their best interest because they know you're a board member. I think for good measure, you should just disclose that, hi, I've just found out that you appointed this person. I want you to know that this is the relationship between me and this person. I think to be on the safe side. Yes?
I want to check, giving information to my son,
Yes.
there's this thing coming,
Yes.
please apply. Then
Yeah.
once he applied,
Yeah.
before the process, I recuse myself.
Yes.
Because there's my son there.
Yes.
But I would have influenced, the initial act. Where does that feature?
Yeah, so then there again, you can disclose if your son does get it, but it's the conflict of interest arises when it's time to make the decision, where you yourself are personally involved in making the decision. There's nothing wrong with saying to your son, apply, but you can't influence the outcome in your personal interests. Yeah.
I'm just thinking about directors general,
Mm.
major Ds.
Mm.
Proposal comes to him, to his office of doing solution X.
Mm.
And obviously because he's not a technocrat, he then takes it to the appropriate division.
Yeah.
They then receive it based on the HOD's referral.
Yes.
How should that be dealt with so that there's no conflict of interest? Because the person receiving it might read it as, I'm receiving this because it's come through the big office, so I must actually approve it.
Mm.
And it must come down here for the decision to be made in one way or the other. And
Yeah.
not being influenced by the HOD. How do you make sure that that situation doesn't arise?
Mm.
Conflict, or people misreading it?
Misreading it. I think to be as open as possible, if you feel that there's a sticky situation, because conflict of interest comes at decision-making time, but ethical leadership is to ensure that you're not even having undue influence on the decision, even before the decision is made. And Babra Deborah is completely right in that the papers will cover it how they'll want to cover it. Okay, so one case on the issue of conflict of interest, unless are there any questions before I go into the case? Okay, another case is Gandolfinger versus African Textile Manufacturers. Quickly on the facts of this case, a minority shareholder took the company and the majority shareholder to court because the company that this minority shareholder held shares in was entitled to certain payments from another company. But now he realized that actually these payments weren't coming in, they weren't filtering into his dividends, what was happening. And it found, the minority shareholder found that there was a resolution by the board of directors in which the directors split this payment between two directors and the majority shareholder. And obviously, there's a clear conflict of interest. You shouldn't have been, actually that was just fraud and corruption because they shouldn't have been misappropriating those funds in any event. But importantly on this principle, the court said that it is an elementary, so like it's the most basic principle of company law, that apart from explicit power in the Articles of Association, this would now be the Memorandum of Incorporation. You can see this is an old case. A director cannot vote for the adoption of a contract or on a matter in which he is an interested party. So that was it's the most basic thing. So the director can't vote that, yeah, actually, we hereby decide to split this payment between ourselves and the majority shareholder, even if the majority shareholder shares it, shares that interest, because you're then acting in your own interests, as opposed to that of the company. And of course, when we have the next session, we'll also talk about prejudicial conduct towards shareholders. So even if you are acting in the interest of the company, but you're unduly prejudicing shareholders, you can also be brought to book.
Would this be related to what is happening with Old Mutual now?
Well, that was disclosed. This Old Mutual saga is, I suppose you're talking about the CEO, Moyo. So his interest was disclosed. I think there are a lot of politics, and we're not receiving the full picture of what's going on there. So yeah, I think it will unfold as it unfolds. What we do is we refrain from commenting. The, to get the payment. Yeah, he overrode the first preference. But you see, I'm saying it's an unfolding story because nobody knows how that decision came about. That's why, the court actually ordered that he be reinstated. One would assume that they assessed his conduct and found that his conduct wasn't unethical. But it's unfolding. So we refrain from commenting as Siba knows.
So if you have organizations like the Premier Soccer League, then that one that means when Pirates issues are discussed, Ivory Coast doesn't say anything.
So I have to apologize, or not apologize. My husband's the soccer fan. I don't even know what kind of entity the Premier Soccer League is. Is it a company? Who holds what authority there? But if it is a company, if it's two different kinds of companies, if Pirates FC is an incorporated company, then there might be conflicts of interest, actually. Yeah. Okay, and then there's also some debate on whether a decision made without compliance to Section 75 is void or voidable at the instance of the company concerned. So that's now just to go. It's a what's the word? It's a theoretical discussion. It's an academic discussion. It hasn't been unpacked in case law, but essentially, let's go back to Tiffany, right? If Tiffany voted on it and her dad got the supplier contract, is it void or voidable? In that, is it void ab initio? Please help me. Void from the word go, or is it voidable down the line? I don't think we need to go into it. Anyway, essentially, can the company revoke that decision on its own, or does the company have to go to court to revoke it? And I think those of you in government, I think, might see this under administrative law. If a decision is made improperly, can the government, just cancel the contract and say, actually, there was corruption here? Our courts in administrative law have already accepted that no, even if it was a corrupt tender award, the government finds out, maybe a new administration comes in and the government finds out, they can't just cancel it. They have to go to court to cancel it. So that's the same principle here in our company's law that hasn't been clarified in the same way. Okay, then the Omar case. Another one of the Tiffany example. In this matter, the court confirmed that non-compliance with the provisions of Section 75, i.e. non-disclosure of one's personal financial interest, renders the particular transaction or agreement invalid unless it has been ratified under Section 75B or validation by the court under Section 75.8. So it's not clear. This isn't a precedent. People don't agree with this case that it is invalid from the word go. Is it invalid later? Nobody knows. Maybe one of you will find yourselves in that situation and you'll need a good lawyer and we can fight it. Okay. Then moving swiftly along, it's also debatable whether the holding of directorships on the board of rival companies in itself constitutes a breach of the director's fiduciary duties. However, it would be almost impossible for the director not to prejudice one of the two or more companies that she serves. Of course, the provisions of Section 75 relating to conflicts of interest will prevent a director from finding themselves in such a position. Example, sitting on the board of Standard Bank and Nedbank at the same time. Can you do it? Is it directly conflict of interest? Standard Bank and Nedbank would never let you do it, but somehow it gets fuzzier with the smaller, medium-sized enterprises. One would think that is a direct conflict of interest because Here, when you're sitting on the Standard Bank board, I'm just giving them as broader examples. When you're sitting on the Standard Bank board, you're acting in the interests of Standard Bank, but the complete rival is one of the other 4 banks, maybe Nedbank. Can you avoid a conflict of interest in that situation? It's quite clear at the top, and such companies would never let it happen, but it's not so clear with your medium-sized enterprises or your rare-skilled enterprises, those that are operating in specialized fields. Okay, and then civics construction. This case is interesting. So what happened here, just quickly to touch on the cases, on the facts, is there was a conflict by the board of, certain members of the board of directors. So let's say Director A and Director B sat on the board of civics, and civics provided a specialized service. I think it was the maintenance of leak sealing. So very niche market. And they sat on this board of civics, and a big tender came out. And as they were on the board of civics, they were very much involved in the tender documentation and the bid and everything for the company. I think they were non-executive director on civics. Then they submit the tender. Whilst they sit on the board of civics, they incorporate another company, Injector Seal. And then they resign from the board of civics and then tender as Injector Seal for the same service, to provide for the exact same tender, to provide the same service. But because they already knew what civics had tendered, what price they had given, they were unduly advantaged when it came time for them to tender on behalf of Injector Seal. And so the remaining board members of civics took them to court, and the court said quite clearly there, it would be a most unusual situation which allows directors of one company to act in the same or similar capacity for a rival without actual or potential conflict situations arising with frequent regularity. So Injector Seal, civics, that's just that whole conversation as to whether you can serve on 2 rival boards. Okay. And yes.
Comment there would be that you're not even allowed to tender anyway, because there is this kind of cooling off period. If you resign from the company, at least you can't just go back and do business with that company. You need to cool off at least a year or 2 years.
Yeah. That's completely correct, and that's the element of ethical leadership, which is a huge focus of King 4, the King 4 codes, which isn't the law, but it's the principles that, even the JSE listings requirements make compulsory. Yes.
For directors, I just want to check if it's someone like, for example, I'm in an organization and there's a tender like we move into cloud. Let's say we give it to Microsoft, then we sign it off.
Yeah.
Then I resign. Now work for Microsoft and support the same organization that I actually gave Microsoft a contract. Now I'm working for Microsoft, supporting the company that I gave a contract.
That's a clear conflict. Yeah.
Is it allowed?
No. No, sir. And as a matter of fact, Microsoft probably wouldn't, even embroil or involve themselves in such a situation. But it happens all the time. So it's a very valid question. People, influence the awarding of a tender here, then they enter into another situation, or they, start working for the tender awardee or whatever. Yeah, it's an issue, and that's why it's important that we discuss these kinds of principles. Okay, so why do we need good corporate governance? And good corporate governance isn't just the corporate governance principles, but also what we've discussed today and what we're going to discuss next month. So, any takers? Why do we need good corporate governance? Like from an economic perspective, from an employee stability perspective, we see, what's happening in the country is really bad. People are losing their jobs. Companies are closing down. VBS, okay, now I'm answering the question. No, please. Oh, yes. Yes. That's a good one. Any other takers? Yes.
I think it prevents the unnecessary bleeding of funds. Right now, our state is bleeding funds. Everyone is pocketing millions in every corner. And if this continues at some point, there'll be no money.
Mm.
One company will have no money to do anything. Like last week I saw in the news, I think it's cutting edge. This bus company in the Northwest has buses that have no petrol. So the community members contribute 5 rand, 10 rand each, pour petrol into the bus after buying tickets to go to work. So they buy tickets before the week, then they get into the bus, it has no petrol, they still pay 5 rand, 10 rand each. And then there's another case where about 500 buses vanished. They are not known where they went to. And then there was money that was given to buy new buses, but second-hand buses were bought for a price much less than what was given out. The country is bleeding.
Yeah.
Yeah, I
Yes.
think it's also
Hanu.
important for us to remember that if you talk about corporate governance and you think about large corporate organizations, it's very rare for the ethics of a corporate, when done in whatever way, good way or a bad way, to not later on impact on the moral impacts of a society. We see something like Steinhoff, absolutely wiping out billions of rands of value, which somewhere down the line is going to impact someone's ability to put food on the table, right? And that's going to impact the family, it's going to impact the morals in that family, and it really impacts people's lives. So I think it's, for any one of us who end up in that situation as a director somewhere, we must remember it's not just the rands and cents of this company, and when this company goes broke, then, we sign the papers and we create a new company. There's very real people behind it, and it impacts their lives in very real ways, not only financially.
Yes. Any other takers? Yes.
Yeah, basically to place full accountability, on decision makers, because the decision not only does it have an impact on their company as a micro, but it has an impact in the macro, which is the economy of South Africa as a whole, and all South Africans. So yeah, I think it's accountability more than anything.
Yes.
Just to add on that, it's also to help to avoid mismanagement
Mm.
and be able to mitigate risk where you can. So if there are processes, so there's always needs to have processes which are aligned to, so that to avoid all those things that you're talking about, people saying, I didn't know that, I didn't know all of that. Create transparency and what processes need to be done.
Yes.
How do we manage mismanagement?
Anybody else? Oh, they don't have the Manupi. Please, please do let us know. Anybody else? Yes.
But I also want to say, on the flip side, I meet a lot of people, particularly in government. Someone will say when they are being charged, what are my children going to eat? But I think you should have thought about that when you were skipping work,
Yes.
embezzling funds, giving contracts around. You should have been thinking, what are my children going to eat if this comes to an end?
Yes.
But it's only when consequences are being enforced that people start screaming. And we've had, in the education sector, we've had a teacher shoot a principal in his own house because the principal was trying to follow due procedure
Yeah.
for a certain act of misconduct by the teacher. And I think it's a decay that leads to the increase of corruption, that people are only being driven by their hunger, but not by responsibility
Yeah.
and accountability.
Yeah, and they don't have a view of the future. What are we going to leave for the next generation if we don't adhere to proper governance? You're completely right. Yes.
I think also it is to avoid civil disobedience and uprising. Because once people see that we have entrusted to you our resources, because we are 58 million, 58 million people, then we have entrusted it to maybe 400 and something people
Yes.
to take care of it. If you mismanage and we see the suffering around us, surely what we'll do will become reckless, we'll burn down the company and say that if we can't enjoy with our families, then we also don't want you to enjoy. So it is just to create this image of fairness. Because it's unfair if you see that you keep on doing the wrong things and then nothing's happening.
Yes, and it's like our chairman said of ULP, Abab Khadebe, that it's consequence management as well. It's very important. Anybody else? Yeah? Yes?
I think also to clearly define roles and responsibilities,
Yes.
and segregate duties and powers.
Yes.
That corporate governance will really help in that.
Just not to, and also to not destroy them.
Yes.
Say like that.
Yeah.
You mentioned that Dutch East India Company, which was there for 200 years, basically collapsed.
Yeah.
That.
100%. And, you know, we all understand the importance of good corporate governance. I hope you also understand the vision of our chairperson and what it is we're trying to achieve here. Because nothing's going to change if nothing changes. And so you being here today, you're part, you know, giving away your Saturday, you know, half of your entire Saturday to be here. You're part of, hopefully, the change that we wish to see in South Africa. Next time, we will discuss some of these case studies in more detail. We'll also have Dr. Reo Koza come and join us. So it's not just theory, but we're also engaging with giants of ethical leadership who have, you know, by themselves, I would say, or not by themselves, they are ethical leaders, but not enough. And so the hope is that today is the beginning of building more and more ethical leaders to really just turn the tide. We hope to turn the tide in South Africa. So with that, I'd like to thank you for letting me speak, and thank you once again for attending this workshop and giving of your time.